Finally, the National Super Alliance last night beat the deadline for the filing of its presidential petition challenging the re-election of President Uhuru Kenyatta. NASA lawyers managed to file the petition shortly before the midnight deadline. The opposition alliance had only until midnight to file the petition. Over 15 lawyers have been hired by NASA, we're told, to make their case. The NASA team wants the August 8th presidential elections nullified over alleged irregularities. NASA presented 20,000 documents, it says, evidence of malpractice in the election. NASA is now expected to serve both the IEBC and Jubilee Party in the coming 2 days. Once served, the IEBC and Jubilee Party will file their responses. And now, just to dissect for us more on this top story, I'm now joined by our panel here in studio. I have Brian Mutier on my far left. He is a governance expert, as well as our lawyer here, Kakai Kissinger, who also has experience as far as electoral matters are concerned. Many thanks, both of you, for joining us.
Thank you, Yusuf.
Let me just start with you, Kakai. Finally, NASA have decided to go to courts. Initially, they had said they're not going to the Supreme Court. Others say they might resort to mass protest, but now it's a legal battle. What do you have to say about that?
Yes, thank you very much. It's now a legal battle. And it's very good that NASA decided to go to court, because that was the only option. You do recall sometimes back with so many options for NASA. And this seems to be the only viable option in terms of going to court. And remember that NASA had been encouraged by all stakeholders, civil society institutions, development partners, observer missions, United Nations, and so forth, and leaders within the region. It really encouraged NASA to go to court and file a petition. Because in a democratic society and country, the only way you can live out your grievances is to go to court. However, NASA has made it very clear that it's not the only option they have. They have other options which they will keep mum and use them only when they want to use them. So it's good that they went to court, and let's hope and see what comes out of this debate. And petitions in this country have a very significant role in democratic governance and structures. Because remember that under the old constitution, we had about 4 or 5 petitions that had been filed. And under the new constitution, this is the second petition being filed. And there are lessons always to learn from petitions. When you look at all those petitions that were filed, for example, there was the Matiba versus Moi petition, there was the Haron Mwau versus Moi petition, there was the James Orengo and 6 others versus Moi petition, there was the Mwai Kibaki versus Moi petition. All those petitions, we learned something out of it. So petitions is not about who goes to court, but petitions about when people go to court, what are the lessons we are going to learn, and how are those lessons going to change the dynamics of democracy and voting and the law?
And above all, they have to have evidence, because that is what the judges are going to act on. Now, Brian, the last time we were with Kakai here, he had given NASA about 6 options, and it seems they have resorted to one of them, which is going to courts. What do you think about that? Was that a right move?
I think out of the many, I think that was the most viable, as he has rightly put it, owing to the fact that this is the only way, a mechanism that perhaps would be applauded by all stakeholders. And when we talk about stakeholders, of course, we are including we as citizens, the political parties, civil society, you know, the registrar of political parties, observer missions, and you know, other friendly nations that perhaps have an interest in our country. And I want to applaud NASA for taking that action, because it's a noble one, owing to the repercussions of the other one, which actually was somehow touted to be the alternative to this one, which was actually a street protest. And you know, the nature of street protests, Yusuf, they are not romantic.
They don't end well.
They don't end up well. So there is likely of bloodshed and all, loss of property and all that. So to me, I think it's the right direction. But to me, it will be a battle of wits in terms of legal minds battling each other. I can't wait to see how they are going to tear each other apart. And the last time we saw such kind of a battle of legal minds was actually when Kethi Kilonzo was actually trying to get absolved on some issues that she wanted. She had been allegedly, of course, found herself into the thick of things in terms of a voter card, which perhaps did not get a good procedural way of landing in a handbag. So that was one of the areas where we saw, you know, who is who in the legal fraternity in Kenya, taking each other's jugular, and it was such an interesting scene for us to watch as legal minds. So we are, I can't wait to see, you know, Gatia, the likes of Rengo, Akina Mutula Kilonzo. These these are, some of the best legal minds in this country.
Kakai, you've seen the sheer size of the documents presented by NASA as the evidence. It's about 25,000 page. And Orengo is also on record having said that they've hired about 25 lawyers for this particular case. Is that unprecedented? Is it something that has happened before?
Yeah, it's not unique to have a kind of evidence based in terms of the number of pages. And we often forget, but let me just remind you of what happened in the 2013 presidential petition. In 2013, when Honorable Raila Amolo Odinga went to court, at that time it was the first petition under the new constitution. And so the issues of evidence was very critical. And we'll come to later on to try and analyze these issues. So what Raila Amolo Odinga did was to file a petition thinking that within time, because you only have 14 days to have this matter determined by a court of law, very strict deadlines.
Will so that be a very short period for the judges and the lawyers?
Yes, and I'm coming to that. And at that time, Raila Amolo Odinga, in the previous petition, underestimated the duration. So then he sought much later to add more papers in terms of supporting his evidence, which were about 800 pages. And you do recall very well the Supreme Court said, now we can't deal into this extra evidence. So what now they have done right now is to be smart. To be smart in terms of filing the petition with almost everything that they will want to rely on to avoid the evidence being expunged on record. Now, it's not unique, number one. Number two, I don't even think that is over voluminous in terms of the petition itself. What really matters in the Supreme Court is critically what is the key evidence. And some of those things, there's what we call pre-trial conference, which will take place before the judgment. Now, during the pre-trial conference, they will try to zero in on issues because the law allows when you look at the Supreme Court rules, they will have to zero down on issues. So they will limit the issues that will be discussed. So some of that evidence could be irrelevant insofar as is it supporting a certain issue that is before the Supreme Court. So it's really not a question of the pages. It's a question of what is so critical.
The content.
The content that is so critical that will help you advocate or push for your case.
But another question is, Brian, before I come to you, why wait until midnight?
Now, the law is very clear in terms of election petitions in this country, is that once the results have been announced by the IEBC. Any aggrieved party, once the results have been announced, any aggrieved party has 7 days to go to court.
Yes.
Now, remember that when you have 4 days, there's the 7 days, the days start running immediately, the IEBC declares who the winner is. Now, remember that for you to file a petition, you must be very, very careful what you are filing in terms of going before a court of law, because it's no longer about politics. It's about evidence-based in terms of approach and pushing your issues. And remember, you are not filing this in isolation. You are relying on evidence that probably is in the custody of the IEBC, which has just released the results. So you still have to go back to IEBC and ask them to give you documents. Now, in most cases, petitioners who file petitions before a Supreme Court will always do it the last day. You remember even in Ghana, the last petition in Ghana. Remember even in Uganda, the petitions in Uganda, they always go there the last day because you are relying on evidence.
But they didn't do it at midnight, I believe.
In Uganda, they did it at 9 p.m.
Oh.
Yes, in Uganda. I do recall that I was in Uganda that time. They filed that petition at 9 p.m.
Yes. So
normally what happens is that there's nothing wrong because the law 7 days, so they had up to midnight to file the petition, and all they required, which they must have done, is to call the registrar of the Supreme Court and say, fine, we are still going to bring our petition late, please wait for us. So the issue of filing late is just being sure that we must file on time, and there's nothing illegal with that.
And of
because if you don't file, then you are caught up with constitutional constraints, and that petition will not go anywhere.
And of course, they have the job of coming up with a watertight evidence. Brian?
Sure. I do echo his sentiments when he talks about NASA trying to burn the midnight oil to beat that deadline. Of course, that's the only best way they could do because they had to take time because they have a precedence, of course, since 2013
yes.
when they were caught, pants down by having not submitted enough evidence, which at some point was rejected because of the voluminous nature. And this time around, they seem to have learned the game, and they are very careful, or they were very careful for that matter, not to make or repeat the same mistakes. And in terms of collectively coming up or amassing all the evidences that they would want to submit, it was a game, that was meant to ensure that they have watertight evidence, although that is now about to be determined by the courts, whether it was really watertight to warrant now a decision in their favor. But again, we have also to appreciate the workings of the Supreme Court. Of course, it does not have all the time at its pleasure. It is limited within 14 days to deliberate upon this issue. So the first 4 or 5 days will be, of course, the preliminary days where they'll be scrutinized these documents, whether some of them are really relevant, whether others are really, important in that kind of court process. And the moment now they'll be settled, that will be maybe the 60th day from the day of submission, is when now they'll be able now to start the whole process proper. And this now will depend, whether the case will go on to their favor will now depend on how they conduct themselves and the kind of evidences that they are, trying to bring on board. But one thing that I want to, which excites me, is that NASA is fighting a two-pronged battle because, of course, they are targeting Jubilee on one hand and the other side.
Actually, something I wanted to talk about.
Yeah.
And Kekai, of course, there's some legal observers who are saying that NASA are going to have a very hard case, first of all, to prove that this election was a fraud, and again, to prove that the extra 1.4 million voters that Uhuru Kenyatta got, I mean, they have to explain where this number of voters came from.
Yes, it's good that we are talking this before the trial begins, because once the trial begins, then we are gagged by the fact that it's a matter before court, so we can discuss. So right now we can say whatever we want to say. But before I answer your question, let me, and I'll take you through why my personal opinion on these issues on electoral petitions, especially presidential petitions. But let me talk about something that he has hinted about, the challenge of the 14 days.
Yes.
The challenge of the 14 days is the constitutional challenge. For some reasons, for lack of wisdom or with wisdom, Parliament and Kenyans decided to have a presidential petition to be handled within 14 days. Now, this has always been a nightmare. And I do recall there has been pushes in the last Parliament whether these days should be expanded and enlarged or not. But when you look at the jurisprudence around Africa, you notice that the 14 days period is in most African countries. If you go to Cote d'Ivoire, it's 14 days. If you go to Zambia, I do recall I was in Zambia and with that challenge, the petition has to be filed in 14 days. It's only Uganda that Kenya is 14 days. It's only Ghana is 14 days. It's only Kenya that Uganda that has a luxury. They have 30 days to deal with the election petition. But here we are stuck with the 14 days. And there are reasons why countries opt for 14 days is because the stakes are very high. The country will be paralyzed and we need to sort out this debate or decision within the shortest time for once for all. Now, when it comes to the issue that you've asked me, and so that's the challenge of 14 days, and we are stuck with the 14 days until we change our constitution. Now, when you ask the challenge you have asked me, I will, as a lawyer, I look at it from the jurisprudence part of it. And when you analyze all African countries that have had presidential petitions, then you analyze, including Kenya. We've had Kenya, we have had a presidential petition in Kenya. In Ghana, we have had a presidential petition in Ghana, in Uganda, in Zimbabwe, and in Cote d'Ivoire. When you analyze these countries, you realize that it's always a very difficult position to find yourself to be in as a petitioner, because any of the African countries have we seen a petition succeeding. So I'm not saying that NASA doesn't have a strong case.
But of
I'm
course,
just saying
out of experience,
is extremely difficult. And I'm coming to that to tell you why it's very difficult. It's extremely difficult.
But again, because Kenya might set up precedents, of course.
No, I'm coming to that because jurisprudence has that it's very difficult to win a presidential election because the courts look at not only the law, but look at the public opinion. Yes. And the courts are completely reluctant to invalidate an election petition because an election petition is a human rights issue and is the will of the voter. So courts always are reluctant to say, I want to invalidate the will of the voter. So courts will say, and some of them have pronounced themselves, that look, even in Ghana, for example, they said, look, if it's the will of the people, we leave the people to have decided. You can only invalidate, according to some of the jurisprudence that has developed over the years, an election petition if you prove fraud. Now, so that brings us to the question of what are the standards of proof that one is required. Because it's only one country in the world that has been able to invalidate a presidential petition, and that's in Ukraine.
Yes.
And in Ukraine, the presidential petition was invalidated because they opted to go for the issue of fraud, saying that fraud is a thing, and so fraud becomes a criminal element. So the standard of proof then becomes a little bit higher for the petitioner, because you can only invalidate an election petition when there's fraud. Now, I do not know the evidence that NASA has. I do not know what points of law they are going to have, but that's my general view, that invalidating an election petition is very difficult.
Yeah.
And Brian, the NASA leader, that is Raila Odinga, talked about, computer-generated results and computer-generated leadership. And of course, he was referring to the Jubilee.
Yes.
But there's a big, huge, number of NASA leaders who were also elected through the same system. Was this referring to just the Jubilee leaders or what?
I think maybe he was actually confining himself to the top leadership.
Okay.
Because if it were to actually delve on the leadership of the other cadres, the governors, senators, then NASA and the Jubilee will be in the same pot because they have been elected through the same process. So I just want to... I picked that he was actually referring centrally on the aspect of the top leadership alone. Yeah. But again, I think just to echo some sentiments that my brother said, I think when he talks about, this being a difficult one to go in favor of NASA, I do not want to see it that way, because in law there is always a precedent, and it's always set at a given time. Not all cases are the same. The dynamics always change, and the fluidity of the law, of course, has to be appreciated in this case.
He was talking out of experience, what you observed somewhere else.
Of course, Ukraine, of course, gave that kind of a fast of many in terms of actually absolving whoever actually was aggrieved. I mean, the president of then actually turning the tables in favor of the petitioner. Remember the U.S., of course, Al Gore and Bush. It never saw the light of the day after Al Gore actually petitioned. In Ghana, of course, we know the case, and in Uganda, of course, we know the issue. And also Cote d'Ivoire, they had also a similar petition. All of them, of course, have never seen the light of the day. So he might be justified when he says they are difficult to prove. But again, when we go to the fluidity of the law, in terms of interpretation, we cannot say that this one is likely to take the same precedence because of the nature of the evidence that perhaps, which we are not pretty aware, but perhaps what can be brought on the table, if the judges will be able to decipher through and see whether they can pinpoint one or two things, then it can go in favor of NASA. But what I want to say is that for a presidential petition, it is normally different to other petitions in the sense that they have to weigh the repercussions vis-a-vis the kind of direction they are giving, because if an election was characterized by some malpractices, they have to look at the threshold of those malpractices, whether they meet certain thresholds. And when they put this in a weigh scale, they have to look at the benefits vis-a-vis the demerits of this kind of ruling that they are likely to make. So if they find that the malpractices were just normal, as John Kerry would rightly put it, in every electoral process there might be one or two deficiencies here and there. If the judges can also take the same line, then you can see that you can find NASA actually not winning this case.
Of course, but if the laws representing Jubilee, of course, that
just before I wind up on that,
to poke holes into the evidence, of course, produced by the NASA. We'll continue this conversation.